the amount is about 200 million shillings.
So he finds Mr. Rigathi Gachagua to have obtained 200 million shillings, is that correct?
To have been unable to explain
200 million
how he obtained 200 million shillings.
What did the judge do after that finding?
The judge directed that the amounts be forfeited to the government of Kenya through the Asset Recovery Agency, which is the body created under the Proceeds of Crime and Money Laundering Act to take care of money laundering. Yeah, Mr. Ongoya, for the Deputy President who was here, and the family stated that that you have no ground at all to bring this allegation in the Senate. What is your specific complaint in the Senate on this allegation? My specific complaint is that when a judge in a functional democracy, in a country of rule of law like ours, when a judge makes a finding against, and the judges make findings against all of us every day, the civil way of challenging that decision is through an appeal. So you appeal the decision. You do not go to a rally and start threatening judges, because then you create fear, and you create fear in the judges so that they are not able to exercise their decisional independence. You can interfere with financing of the judiciary. You can interfere with many, many other things. But let's not take away the decisional independence. Honorable Mutuse, do you have any evidence that you've submitted to the Senate to prove this allegation of, you're calling it interference with the independence of the judiciary? Do you have any video evidence, any evidence? Yes, I have presented video number 14 and video number 15. I request the video, Mr. Speaker, to be clips of the... Begin the bulletin with the war on the judiciary, where Kenya Kwanza administration is making good on its threat, with the Deputy President Rigathi Gachagua now filing a petition to push for the removal of a judge from office.
Gachagua says he will on Thursday file a petition with the Judicial Service Commission to push for the removal of Justice Esther Maina, who handled an economic crimes case against him in 2022 for alleged corruption and misconduct. Now, speaking in Iten, where he accompanied President William Ruto for a church service, Gachagua told the Chief Justice to first clean up her house by dealing with pending cases with the Judicial Service Commission. Now, in the sustained onslaught against the judiciary, President William Ruto vowed to deal with unnamed government officers he described as incompetent, saying his administration will slay the corruption monster that has reared its ugly head in various arms of government. Chemitai Goin reports.
After Chief Justice Martha Koome invited Kenyans with complaints over the conduct of judicial officers to submit their lamentations to her office, the Kenya Kwanza administration, through Deputy President Rigathi Gachagua, has taken the challenge, with the DP announcing that he will file a petition this week.
Amechallenge sisi tutoe ushahidi. I will lead by example. On Thursday, this coming week at 2:15, I will personally present a petition before Lady Chief Justice Martha Koome against Justice Esther Maina for her removal from the judiciary for misconduct and corruption. Mimi mwenyewe nitaongoza, because sasa unajua, sasa si ametuuliza. Sasa tuko tayari, mimi ndio taongoza kwa executive.
Gachagua relieving his July 2022 incident where 202 million shillings was seized to the state after Justice Esther Maina ruled the money was proceeds of corruption, having been acquired through dubious means.
Huyo judge, through corruption, declared my hard-earned wealth proceeds of crime without giving me an opportunity to be heard. Against the rules of evidence, where he who alleges must prove. We made an application to cross-examine the investigator, akakataa, kwa sababu anajua there is no case. Na evidence tuko nayo vile ilifanyika.
The Kenya Kwanza Battalion hitting out at Koome for being quick to defend judicial officers, some of whom they claim were not beyond reproach.
I think we can stop there. We can stop there. Now, Honorable Mutuse, it looks like in this public forum, statements were generally made against the judiciary. Is that correct? By all politicians who attended?
Yes, it will it is correct that even others who were there made statements against the judiciary, and there is no problem with that.
Yeah, yeah. So what is so extraordinary? Mr. Ongoya said, there's nothing extraordinary about your complaint.
My complaint is extraordinary in the sense that the Honorable Rigathi Gachagua was not complaining about the judiciary. He was complaining about a specific judge for a decision that she made, a finding that she made against him. It was not about corruption in the judiciary. It was not about inefficiency in the judiciary. It was not about how the judiciary runs. It was about huyu judge alisema mali yangu ni mali ya wizi.
Now, in that public statement, the deputy president says he has evidence on corruption against Lady Justice Maina. In his response filed before this House, have you seen any evidence adduced for corruption against Lady Justice Esther Maina?
I have not seen any evidence to show that indeed he has evidence of corruption influencing the judge to make the finding that the 200 million were proceeds of crime.
Okay. Now, this judgment
which leads me
to
my conclusion that this is personal vendetta.
What do you mean by personal vendetta?
Personal vendetta is you are here in Senate representing your people, you make decisions in Senate, you make debate in Senate as part of your constitutional mandate. You mention people who are not doing things right, and when you get out there, they threaten you. They tell you, when you say that again in Senate, I'll kill you.
Okay.
Or I'll get you removed from Senate, to create fear. Personal vendetta.
Now, this judgment, which you've said is available at page 60 to 77, and you quoted it of volume 2A of your documents. Could you by any chance know what happened to this judgment?
Yes, I am aware that indeed the Deputy President did appeal against that decision.
Yes.
But on becoming Deputy President, the same was settled through a consent, a compromise, as it would be, and the money was returned to him.
The money was returned to him. Have you seen this consent that was recorded at the Court of Appeal?
Yes, I am aware of the consent.
Okay, you are aware?
I am aware that the consent was not arrived based on the merits or demerits of the case.
Okay.
It was just government bodies, because leadership has changed hands, and the second in command now is powerful. A few government bodies, Asset Recovery Agency, they went to court and they said they want to withdraw the case.
Finally, Honorable Mutuse, is there a decision of the Court of Appeal? A decision of the Court of Appeal upsetting or setting aside this judgment and the finding by Lady Justice Esther Maina about
to my understanding, and the lawyers in the House will also have the same finding. There is no decision of the Court of Appeal.
Have you seen any of this response?
Overturning Justice Maina's decision, and therefore Justice Maina's decision remains good law.
You have come through the response by His Excellency Rigathi Gachagua. Have you seen any appeal decision setting aside?
No, there is
any order setting aside the judgment?
The consent is there, but there is no decision on merit from the Court of Appeal.
Okay. Honorable Mutuse, let's go to ground number 8, allegation number 8, and briefly explain to the...
Maybe before we leave there.
Yes.
It is important in terms of, because we are complaining about Article 160.
Yeah.
For me to just read 165. A member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function.
Okay.
Because that is a particular section we are complaining that the Deputy President has violated.
Okay. So in your opinion, does undermining the independence of the judiciary amount to gross violation of the Constitution?
Indeed, it amounts to gross violation of the Constitution. It will remember that we have three arms of government: the executive, the legislature where we sit, and the judiciary.
Is it proper for the Deputy President of the Republic of Kenya to make this kind of attacks? Is it proper in your opinion?
It is not proper at all.
Okay. And what, in your, again, to just wrap that point up, What channels
Council, before you
exist?
get there, you referred to a consent. Is it contained in any of these bundles? The senators would wish to look at that consent.
Honorable Mutuse, you said you have seen a consent. You are aware about it. Have you seen the consent?
It is not filed in our documents,
Yeah.
but in my ordinary course of business, I am aware of the consent.
Okay.
If it becomes necessary, the Senate has the powers to recall it. In fact, it is a public document because it is reported under Kenya law reports.
Fair enough. Let's go to allegation number 8 because of time, so that we don't take a lot of time and finish our time. What is the substance of your allegation number 8? Briefly, ground number 8.
Ground number 8 is that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 129 of the Leadership and Integrity Act. And basically here, it is on two folds. The two sections that we have cited, Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act, speak to state officers misleading the public, spreading falsehoods. And on the issue of Justice Maina, as we have shown evidence, it was personal vendetta because the Deputy President was attacking the judge based on a decision the judge had made. On the second one, in terms of the particulars, His Excellency Rigathi Gachagua recklessly and unmindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, as well as his membership to the National Security Council under Article 240 of the Constitution, both being positions that require one to be discreet and tempered, especially during moments of national crisis, addressed Kenyans on live television in Mombasa County and publicly made sensational statements against the National Intelligence Service, an essential national security organ, its Director General, and the officers.
And also, you can hold on there. Do you have evidence to prove these allegations about a live television statement in Mombasa by the Deputy President? Do you have any evidence before this House?
Yes, we have annexed our video number 15.
May I request we play video number 15, please, Mr. Speaker?
Where did the rain begin to beat us? Where did we stop listening to the people? President William Ruto and I were the darling of the Kenyan people. By listening to them, by engaging them. And as a government, we have established institutions to ensure we not only listen to Kenyans, but also genuinely understand their concerns. We invest significant resources in these institutions, particularly the National Intelligence Service, for this purpose. It is clear there has been a failure in the intelligence and advice we are receiving, particularly concerning crucial government policies. The President of the Republic of Kenya today has admitted that it has come to his attention that the people of Kenya did not want anything to do with the Finance Bill 2024.
Honorable Mutuse,
President,
maybe we can...
There is an important
Yeah, okay. You
has now agreed that we need to listen to the people.
Yeah.
And I sympathize with my boss, President William Ruto, because this information was not available to him. I know President William Ruto. Had he known 2 months ago that the people of Kenya did not want anything to do with Finance Bill 2024, he would not have asked his parliamentary party to push it through. Yet, we have an organization paid by the public to give him and government such information. And that is where the problem is. We have a dysfunctional National Intelligence Service that has exposed the president, the government, and the people of Kenya. Had the National Intelligence Service briefed the president 2 months ago about how the people of Kenya feel about the Finance Bill 2024, so many Kenyans would not have died. Property would not have been destroyed. Offices would not have been touched. There would have been no mayhem. But they slept on the job. It had to take people to die, property to be destroyed, protests across the country for the president to know the truth of what the people of Kenya feel. Yet, there is an organization paid for by the public to brief the president and the government about the feeling of the Kenyan people. Officers of the National Intelligence Service, officers of the National Police Service have told me in confidence they did not get advance intelligence briefs about the magnitude of the protest in Eldoret, in Kericho, in Nairobi, in Githurai, in Embu, in Nyeri. Since independence, there has been protests around Parliament. Never have protesters invaded and gotten inside Parliament. Senior officers have told me in confidence they did not have an advance intelligence brief about the intensity of the protest so that they prepare in advance. The National Intelligence Service slept on the job. And the problem is simple. The Director General of the National Intelligence Service, Nuruddin Haji, was a junior officer in the National Intelligence Service before he was appointed as DVP. When he was appointed to the office of the Director General, because of inferiority complex, he chased away all the people who were senior to him when he was in the service, therefore crippling the capacity of that service and making it dysfunctional. 3 directors were chased away and reassigned to desk jobs in ministries.
Mr. Speaker, sir, we can pause it at that because of time. We've captured the parts. Now, Honorable Mutuse, the Deputy President recently addressed a press conference where he rubbished this allegation. He said it's pure hogwash, nonsense upon stilts. What is your specific complaint against the Deputy President in this allegation?
2 specific complaints. One, the Deputy President is a member of the National Security Council. And if he has any complaints against the National Intelligence Service,
yes,
who also sit in the National Intelligence Council, he can raise those concerns there. So that we promote institutional leadership.
You mean the National Security Council?
The National Security Council created under Article 240 of the Constitution.
Yes.
And the Deputy President has forum. And like all other ordinary citizens, senators included, us, we can complain out there because we don't have an official institutional forum. The Deputy President has forum where he can raise his concerns. Number 2, this was a time of monumental crisis in the Republic of Kenya. And the statements were sensational and they would have made Kenyans to believe that our security organs are not functional and would have easily led to citizens running amok and the Republic getting torn apart and our national fabric getting destroyed completely. But even more importantly, I had learned Counsel Ongoya refer you to your oath of office. And I would wish that he also refers his client to the oath of due execution of office that he did swear. In the oath of due execution of office that the Deputy President took on ascension of office, it states as follows: that I will not directly or indirectly reveal such matters as shall come to my knowledge in the discharge of my duties and committed to my secrecy, emphasis, secrecy. He has said in the clip that we have played that officers of the National Police Service have told him in confidence that they had not received advance intelligence reports. That is the But that is what was contemplated by this oath of due execution of office, what Senior Counsel Orengo called addressing fears. That if a matter is committed to you as a state officer in secrecy, it must remain in secrecy. If you take it to a public press conference, then you have gone against your oath of office, and that is an impeachable offense.
This oath of office that you say the Deputy President takes, is it anchored in any clause of the Constitution?
Yes, the oath of office is in the 3rd schedule of our Constitution and therefore part of our Constitution.
Can you read Article 148(5)(a) of the Constitution?
Even to begin with, under Article 74 of the Constitution, before assuming a state office, acting in a state office, or performing any functions of a state office, a person shall take and subscribe the oath or affirmation of office in the manner and form prescribed by the 3rd schedule or under an act of Parliament.
Okay. And what about Article 148, paragraph 5A? What does it say?
Article 148, paragraph 5A.
Yes.
It says the Deputy President-elect assumes office by taking and subscribing A, the oath of affirmation of allegiance, and B, the oath or affirmation for the execution of the functions of office as prescribed in the 3rd schedule. So it is a constitutional issue.
Finally, the Deputy President in his press statement the other day, he said, even in other countries, the US, stable democracies, it's not uncommon to see heads of intelligence institutions being attacked or criticized by public officers. What is your comment about that specific remark?
Even in our country, it is not uncommon, but it depends on who is doing it. The Deputy President of the Republic of Kenya cannot behave in a manner that disparages the institutions of the state that he was elected to superintend, especially so when he has official institutional forum to raise those concerns.
Is there a forum where the Deputy President can conveniently